Please be seated. Looks like we're scheduled to hear two arguments this morning. The first one is styled People v. Berdahl. We've set this for an hour. Looks like both counsel are squared away. Mr. Cooper, why don't you begin your argument when you're ready?
May it please the court, I'm Andrew Cooper for the people. Where an officer has a reasonable basis for placing a person in a patrol car, they should be allowed to conduct a pat-down search for weapons prior to the person being in the patrol car. I think a good place to start in thinking about the officer safety issue that's presented in this scenario is with actually Terry versus Ohio. That case involved what I'll call on-the-street encounters, where an officer is approaching someone on the street or approaching a car that's been stopped in a traffic stop. And although Terry is normally rotely cited for the proposition that a pat-down can occur in that scenario only if the officer has a reasonable basis for believing that the person is armed and dangerous, the articulation of that rule does not mean that the Supreme Court was saying that in the absence of a basis for thinking the person is armed and dangerous, that the officer is necessarily safe. The officer isn't safe. An officer is vulnerable in every police-citizen encounter, but in the on-the-street scenario, the officer has tools available that aren't available in the context of the patrol car. In an on-the-street encounter, the officer can manage the amount of distance between the officer and the person. They can decide when to approach. They can decide if they need to retreat. And none of those tools are available in the scenario of a patrol car. Once someone is behind the officer in a patrol car, the officer is inherently vulnerable. That's the basic reason for adopting the Gao test. Sure, there's a balancing of interests, and of course, a person has a privacy concern with avoiding the intrusion of a pat-down search. But Terry also acknowledged that a pat-down, a frisk for weapons, is not a full search. It is more limited. And when weighing that more limited interest in avoiding the pat-down search against the officer's extreme vulnerability once the two folks are in the patrol car, the Gao rule is justified. The overwhelming majority of courts that have squarely addressed this issue have agreed that the officer is extremely vulnerable in the patrol car setting. There are a handful of those cases, the minority actually, that layer an additional requirement, which is that there be a consistently followed policy. But even those courts necessarily are recognizing the officer's inherent vulnerability. Otherwise, searching everyone through a consistent policy itself would be unreasonable.
Well, let me ask about that, Mr. Cooper, and good morning to you. So I guess my question would be, is there any limit to the officer's discretion? I have to say, I mean, your rule makes some sense to me, but in this case, from what it appears, the officer didn't search the woman, the girlfriend. And I have some concern about saying the reason for a policy is that it avoids unfettered discretion. You know, what would we have if you have an officer who searches only people of one race or only men but never women? That would cause me some concern. So help me understand what the limits are to an officer's discretion under the rule you're proposing.
That was the concern in the jurisdictions that follow what I'll call the McCargo rule, because the Second Circuit case of McCargo articulates that. That's their concern. In those jurisdictions, there are no restrictions on the officer's ability to place the individual in the patrol car. So the concern is that in every traffic stop or in every police citizen encounter, the officer will say, I'm requiring you to sit in my patrol car, and once I've imposed that requirement, I get to pat you down. That effectively allows stop and frisk of anyone who's been detained. And that's why those courts require a consistent policy. Colorado doesn't have that issue because there are a couple of cases decided by this court that put Colorado in a different camp. Colorado requires a reasonable basis for putting the person in the patrol car in the first place. And those cases are Chavez-Barragan and Fines. In Fines, the individual was validly removed from the, this was a passenger being removed from the car that was valid under Maryland versus Wilson, but then the officer required her to go to a position behind that car. That required an additional justification, simply to move to that location. And then Chavez-Barragan addresses it even more directly by saying, sure, removing the driver from the car was automatically proper under the U.S. Supreme Court decision of Mims, but placing him in the patrol car depends on the circumstances. There needs to be a basis for doing that. And that's what is the restriction on the unfettered decision.
Sure, but once there's a basis, can the officer say, I'm just going to search members of this race? I'm just going to do a pat-down if you're African American, or I'm just going to do a pat-down if you're a male. That's my concern. You know, okay, there is some restriction, I agree with you. What do we do past that? I mean, would it be okay if we have an officer who just searches men? I say search, I mean just as a pat-down of men.
This question really is about the U.S. Supreme Court case of Wren versus United States, which says that in all of these determinations, whether it's probable cause to arrest or reasonable suspicion for a stop or an officer safety concern, as long as the officer has the ability to articulate objective facts on which the conduct is assessed, then the court does not look beyond that and look to the underlying motivation. That's the legal answer to that question, and that's the U.S. Supreme Court's guidance on that. Some folks, some jurists might disagree with that, but that is what the U.S. Supreme Court has said in this context regarding the Fourth Amendment. And the other thing to consider is when you look at these cases that are before you, that's not what's happening here. Neither of these individuals were selected out on, some sort of basis like that. And when you look at the reality of what's going on here, and you have two officers from different agencies, both who testified, and the district court found their testimony to be credible. They both testified this is their regular practice to do it.
But why didn't they search the girlfriend in Burdal then, if that's the regular practice? They didn't follow their regular practice.
Well,
and I keep saying search, I apologize. You know what I mean, doing a pat-down.
There's several answers to that. First of all, the district court made that as a factual finding based on the officer finding less believable on that particular point, the officer who was looking at his report. And, I don't want to ask this court to revisit the factual findings. We don't need to do that, but a different fact finder might have found just the opposite. Well, the officer who's just looked at his report actually is the one who's most current on the information. But beyond that, why was there a one search but not the other? On these factual findings, the most logical explanation is it's just a mistake. It's an oversight on one occasion because the judge did find both officers to be credible, meaning they were testifying truthfully. And you can make a mistake about whether you followed your consistent practice on one occasion, but you don't make a mistake in articulating that this is my consistent practice. If the officer said that's his consistent practice, that is his consistent practice. So, you know, there's all sorts of reasons why it might have occurred as an oversight on this particular instance. You know, it's the end of a long shift early in the morning. It's cold out. The officer has just been noticed that the man, after the officer offered, well, why don't you get anything that you need out of your own car before we go, the man went over and retrieved something. So the officer may very well have been curious about that, wondering, well, is there something on this person? So there's a whole host of reasons why a mistake might have occurred on one occasion. And just like in the inventory search of an impounded vehicle context, I don't think that a one-time mistake means that, well, okay, this officer is forever unable to do searches of this type, whether it's inventory search of an impounded vehicle or searches of this type. That's just not the way the rule can play out. So even if this court were to go to the McCargo route and say there must be a consistently followed policy, here both officers said there was a consistent policy, and at most what might have happened is a one-time oversight, which the officer, if you look back on it now and saw there wasn't a video, but if there was a video of him not searching, he might think, holy smokes, what did I do? I put myself in danger. So that's my answer to that question.
Thank you, I appreciate it.
Could I ask a question? You started off talking about a Terry stop. Do you think an officer could create his own danger by approaching somebody as a contact short of a stop and then say, I get to pat you down because I'm in danger being this close to you?
Where there's no basis for approaching the person and it's merely a consensual encounter. I guess I don't know the answer to that question. That would be a more problematic scenario, and one that would arise in the on-the-street encounter. I don't know that it would arise in this context.
I guess part of the reason I'm asking that is trying to flesh out, you wouldn't be arguing that an officer could do a pat-down of somebody in his vehicle if the person didn't have a choice whether to ride in the vehicle. Your whole argument is based on that this is a consensual decision on the part of the passenger to ride and be searched or patted down in order to get that benefit. Is that right?
Well, that's my Roman numeral II argument. My alternative argument to the Gao rule, which is in my briefs Roman numeral I. Let me answer your question in the context of the Gao rule and then perhaps move on to the consent realm. Here's why what you just articulated doesn't always work, which is sometimes a person who has been detained and is being instructed to be put in the patrol car quite reasonably under Chavez-Barragan, maybe because the officer has reasonably ordered the person out of the car, the driver out of the car under MIMS, and then due to the heavy traffic, the only safe place to put the person is in the patrol car. That's not a consensual entry into the patrol car. The person has been seized. But nonetheless, I would say, well, under the Gao rule, the officer ought to be able to conduct that search.
But in that situation, you'd agree there has to be a justification for the seizure initially. Is that right?
Correct. And specifically for the seizure that's found in the placement in the patrol car, yes. Yes. But then moving to the sort of my alternative argument, if this court were to reject the Gao approach and further reject perhaps the McCargo approach and say the only way that a pat-down can occur is if the individual consents to it, then I would say certainly in the scenario which you have here where there's a consensual patrol car ride, the officer absolutely can condition that ride on the pat-down search.
May I jump in, Chief?
Please.
So this brings up a question that I have, and that is if it can be resolved more narrowly on consent, as you suggest in your alternative argument, why should we make new law on the first issue?
Well, for one thing, it would be helpful to have the guidance for police officers so that it addresses all scenarios. But let me answer that question a little more deeply in the consent context. Certainly, if you accept what Mr. Berdahl has argued regarding consent here, there's a problem with resolving the case on the basis of consent, because what Berdahl has argued is because this individual was in dire circumstances and was in great need of the ride, they could not voluntarily consent. So that's problematic. What that approach means is that, okay, officers can provide the courtesy ride to those who are in the least need of it, but can't provide it to those people who are in the greatest need of it. That's problematic.
Did you have another thought?
Well, and
I'm not questioning the adequacy of your previous thoughts. I just was going to move in another direction.
well, sure. And then, I mean, there's other scenarios where the person might truly be unable to consent. For example, they're unconscious. The officer gets the person into the car, but reasonably thinks, well, this person might wake up, and so they ought to be able to search that person. Or the injured victim, there's all sorts of scenarios where the person might, there's certainly going to be an argument about whether the person is giving valid consent.
So I was going to ask you about the flip side of it. You're talking about how Berdahl may have had no meaningful choice. I wonder if the police officer had a meaningful choice. In other words, imagine that there had been a discussion about consent and Berdahl said, you know what, I just realized I still got this stuff in my sock and, I don't consent or whatever. He decides he's not going to consent. Under those circumstances, can the police officer drive off?
Yes.
Okay.
Yes, because the police are under no obligation, certainly no constitutional obligation to function as a taxi service for individuals. As much as we would like the police to provide assistance of this type, as much as it's good policy, there's certainly no constitutional requirement.
Well, never mind constitutional. How about just any legal obligation? Is there the potential for liability if the person subsequently died of hypothermia? I mean, maybe that's an unfair question to you right now, but I'm just thinking out loud about this.
I think it would depend on departmental policies. I think there would have to be a basis for saying that the police did not follow some procedure. And as Colorado does not have a statute that mandates that police give rides of this sort. It's more of a departmental decision and an individual officer decision, and typically the departments are going to give the officers discretion and certainly aren't going to require the officers to give the rides if the officers do not feel safe. So I think that's the answer to that. The reason that I was focusing on the constitutional obligation, though, is because absent a constitutional obligation to provide the benefit of the ride, the officers absolutely can condition the benefit of the ride on the surrendering of a constitutional right. And, there's a series of cases that I've cited on that. Find my place here. DeShaney versus Winnebago County and Town of Castlework versus Gonzalez established that there's no due process right to the receipt of the benefit. DeShaney says there's no substantive due process right. Gonzalez says there's no procedural due process right. And Wyman versus James, all these are U.S. Supreme Court decisions, in turn says that where there is no constitutional right to the receipt of the benefit, the government absolutely can condition receipt of the benefit on an agreement to search. That, Wyman versus James was welfare benefits. The government program says if you're going to receive government welfare benefits, you need to, in this particular program, you need to agree to the search of the home. That's constitutional, and that's why conditioning the patrol car ride can be made conditioned on the ability to search. And the cases that the defense has cited to the contrary are distinguishable. They've cited University of Colorado versus Darden, a case decided by this court. But if you look at really towards the end of that opinion, the basis that that case is being resolved on is that there was nothing in the record to show that these student athletes who are being required to undergo random drug testing for their scholarship didn't know about that at the time that they were applying for the program. And if they had been aware of it, they might have chosen to go to a different school. And the same is true with the U.S. Supreme Court decision that's cited in that, which I think is Perry versus Sinderman. That's a faculty member who is already in the job and has obtained tenure, and then is told, oh, by the way, you have to give up your right to a hearing before being fired, and that can't be done. Those people already have something Mr. Baldall did not.
Mr. Cooper, well, go ahead.
If I could bring you back to the breadth of the rule that you're asking us to adopt here. You seem to be relying pretty much directly on the Gao rule as it was articulated by the Colorado Court of Appeals. And I'm wondering if that's really necessary here, because you talk about a reasonable basis to place the person in the car, but neither of these cases need to go that far. I think both of these are strictly courtesy ride situations. And so why not simply adopt a rule that's based on that more narrow holding? If the person is willingly accepting the ride or has requested the ride, and you're saying it can be a pat-down, a condition of that ride can be the pat-down search, why isn't that sufficient here?
Sure, and certainly the court could resolve it on that basis, and I suppose I couldn't be horribly disappointed if the court resolved it on that basis and found it in our favor, that where it is a consensual ride, a courtesy ride, that the police can automatically search, then that, from my perspective, would be a satisfactory way of resolving the cases. But there's always going to be an argument about whether the person, in fact, wanted the patrol car ride, was consenting to the patrol car ride, and there are these other scenarios. And the police benefit from a bright line rule. And although, you know, much of the guidance in any of this Fourth Amendment context says to consider the totality of the circumstances, there are certain scenarios where the U.S. Supreme Court absolutely has created the bright line rule. You can order everybody out of the car, that sort of thing. So that would be my pitch for the creation of the broader rule.
I feel better because I was thinking along the same lines as Justice Marquez, so it makes me feel good. My question is, again, along the lines of scope. The basis of your argument is, you know, when they get in the patrol car, the police does, they lose the ability to navigate the distance and see the person and those kind of things. But your rule says something about just putting someone in a patrol car. Is there not also the requirement that the police officer be in the patrol car at the same time? Because that seems to negate your rationale.
Well, and that's a great question. Just as I would be okay with the rule that Justice Marquez was suggesting are the basis for resolving it, I would sort of be okay with a rule that said whenever the officer had a reasonable belief that the officer also was going to be in the patrol car. But the reality is that reasonable belief is always going to exist because modern patrol cars function as the police officer's office. That's where their communication systems are. That's where their ability to, you know, access the database is. That's where their other items are. So even if the officer initially is thinking, well, I'm just going to put you here while I do something outside of the car, in every scenario, there's going to be the possibility that the officer is going to need to get back into the car, even if they're not planning on going anywhere.
I'm just trying to find a way to prevent abuse where the police officer kind of tries to put him in the car to form the basis for the search without any, I guess I'm just trying to put some bumpers on the sides.
Well, again, I don't think there's a need to place that bumper there because of Chavez-Barragan, which requires that there be a reasonable basis for the person to go into the patrol car in the first instance. If the officer later needs to get into the patrol car, no matter how sure the officer is that they're not going to, then what would they need to do? They would need to remove the individual from the car, pat them down, put them back in, and when you talk to the police, they will say, the more you move someone around, the more you increase the risk. So the idea of putting someone in and then later realizing, oh, now I'm going to have to be in the patrol car because something over here has happened and I need to call it in or access the database. Now I'm going to have the person come out and pat them down. That increases risk. We don't want to create risk where we're trying to avoid it. If I may, I would like to, if I would ask to reserve the rest of my time.
Good morning. May it please the court, Mr. Chief Justice. I'm Britta Cruz on behalf of Brent Berdahl. In the state's reply brief, it says that officer safety is an exception to the Fourth Amendment. That's not true. Officer safety is not a Fourth Amendment exception. It's a government interest, and a legitimate one to be sure, but one that is not present to the same extent in every circumstance. And here, the state must establish that the risk to officer safety is present to such an extent as to justify not just a brand new exception to the Fourth Amendment, but a bright line rule, and not just a brand new bright line rule, but one that will be applied at the sole discretion of individual officers and against ordinary citizens not suspected of any crime who are merely seeking to invoke the caretaking function of the police. Neither this court nor the United States Supreme Court has ever countenanced such a rule in the name of officer safety, and this court should decline to do so now. Indeed, it appears that the state is conceding that something less than this rule would be appropriate. Just hearing the state's argument, something really struck me, which is there were a lot of answers that were along the lines of, it depends. What about this set of facts? What about that set of facts? That's the exact point of having a reasonableness standard and not a bright line rule, is that different facts matter. What is the nature of the transportation? Is there a duty? Is it a purely courtesy ride? What is the nature of the person to be transported? The Supreme Court has recognized that there are different risks presented by different people under different circumstances. For instance, in an arrest situation, the risk to officer safety is heightened by a couple of factors. We have the fact of the arrest alone. That is a high-intensity situation involving close proximity. It's a hands-on interaction. Another risk factor is you're dealing with a suspected criminal who the Supreme Court has recognized have inherent motives and incentives to harm officers, including to effect an escape, to prevent the discovery of evidence, and even out of a pure sense of hostility having been arrested. And then a search situation often involves the element of transportation, which, as the Attorney General argues, involves a confined space and the vulnerability of a distracted driver. And so what happened in that context in the Supreme Court in Chamel and Robinson is the risk factors went up and up and up, and we've got high risk. And then on the other hand, the privacy interests involved We're talking about an arrestee. That is a greatly reduced expectation of privacy. And so the privacy interest is way down here. And so the accommodation of these interests that the Supreme Court reached was so long as the officers have probable cause, they don't need a warrant, so long as they have probable cause, they can conduct a full search. This court did accommodation of interests in a similar situation in D'Andrea. Now, the big distinction about D'Andrea is unlike a search incident to arrest, this is not a criminal arrest. It is a civil protective custody. That's the statute concerning when an officer encounters someone who they have probable cause to believe is so intoxicated to present a danger to themselves and others. And so, although not a criminal arrest, it is a custody situation. And so again, you consider those risk factors. You go up because of the nature of the custody. And then who are you dealing with? It's not an arrestee, but it is someone who is by definition a danger to themselves and others. And so you've got an increased officer safety risk. On the privacy side of things, however, unlike an arrestee who has a greatly reduced expectation of privacy, this court recognized that ordinary citizens are entitled to maximum weight for their privacy interest. And so here you've got an increased danger, risk factors, including transportation, which is a similar factor in those two cases, but you have an increased privacy right. And so the accommodation of interest that this court reached in that case was not probable cause to believe someone is under arrest or armed and dangerous, but probable cause to believe that this person is by definition a danger to themselves and others. And then because we're dealing with a heightened privacy interest, not a full search, like search incident to arrest, but instead a frisk. And so you see in these cases that it's not that the government interest, the stronger it gets, that it's like a seesaw and the privacy rights go down. These are two independent axes. And I'm a really visual person, so when I'm thinking about this, I'm thinking of these scales. And that's what this court is required to do, is accommodate those interests. And so those are two cases involving a government interest in officer safety, yet in both of those cases, you have the protection of particularized suspicion. Both of them require probable cause. And then the level of intrusion is calibrated to the privacy interests at stake.
None of these, the person in Mr. Berdal's situation has a right to a ride in the police car. Is it true? There's no right to get a courtesy ride here.
Right. There's no record here that there is a duty, a legal duty to transport.
Sure. So tell me why, I mean, the Fourth Amendment touched on is reasonableness. Why is it unreasonable for a police officer to say, you know, before I give you a courtesy ride, I have to do a quick pat down, whether it's an abundance of caution or anything else? Why is it unreasonable? Isn't, you know, one mistake it costs somebody their life? Why is that unreasonable?
It's my position that that's not unreasonable.
No,
that would be a voluntary.
Maybe I didn't ask it correctly. Why is it unreasonable to say a police officer can do a limited pat down if you're going to get in the police officer's car? That just seems to me common sense, frankly, but maybe I'm missing it.
Well, I think what Your Honor is describing is just the voluntary consent exception to the Fourth Amendment. If indeed this is a choice to be made, then that choice should be presented. And that is what is different about Mr. Berdal's circumstance. The choice was made for him. And that is a resolution of voluntary consent under the established standards. That is an existing exception. I believe that that is a perfectly adequate way to resolve the case, is to recognize that existing exceptions to the Fourth Amendment accommodate both the government interests and the privacy interests. If the officers have an articulable reason to suspect someone is dangerous, they can absolutely frisk even without consent under Terry.
Can I ask you sort of two questions? First, how would you respond to the argument that in a situation like Mr. Berdal's, and in a lot of situations where the officers might want to give someone a ride because they're in danger of dying, asking for consent will always seem to be coercive, and so consent will never be voluntarily given?
Well, consent is a totality of the circumstances test, and that test is equipped to handle various circumstances. And so it would just require an analysis, as in any other voluntary consent case, of what are the factors. And I think what's important about Berdahl is when the Court of Appeals remanded Berdahl the first time, they were right in the sense that we don't focus purely on the subjective circumstances. So the fact that Mr. Berdahl was in a life-threatening situation, again, I concede that the officers did not place him in that situation. So yes, that's part of his subjective circumstances, but when you resolve voluntary consent, you have to, the overall test is whether the police action could reasonably appear coercive, and that element may not be present in every case. Here, it was because of the assertion of authority to search. We don't have a consent here because there was purely acquiescence, and acquiescence isn't consent, and it's certainly not voluntary consent. And so I think this is what the California Supreme Court was getting at in their case Scott, that's cited throughout the briefs, which is that the officers have to give the citizen the choice, and it might be a tough choice, but that is the nature of consent, and this court is equipped to resolve that question under existing consent framework, which again is the totality of the circumstances. Now, when you add the element of, again, I think we can resolve this on the fact that there was no choice given. If there is a choice given and the officer...
I'm sorry, can I interrupt you? No choice given as to what? What do you mean? No choice because of the circumstances? It was cold, he had no choice but to enter the car?
No, the officer did not give Mr. Berdahl the choice of accepting the ride and being frisked or declining the aid.
So help me understand that as a record matter, because it seems to me that the sequence of events very strongly suggested that this was a condition. It was merely a condition to enter the vehicle, just as it had been a condition to enter the deputy's patrol car at the outset.
Well, I would direct your honor to the Supreme Court case law in Bumper, Royer, a very old case, Johnson, which is that consent requires the option. And when the officers assert lawful authority to search, they don't ask for consent, they don't present it as a choice, that is not consent, and that is not voluntary consent.
And I guess I'm trying to draw the distinction between I'm patting you down just because I'm going to pat you down. I have some independent reason to pat you down versus I need to pat you down because I'm about to give you a courtesy ride, and that's a condition of the ride. Do you see the difference?
Yes, and we don't have a record of the officer saying, this is a condition of your ride, I'm going to pat you down because I'm giving you a ride. The exact quote is, I'm just going to conduct a pat-down frisk. Under established precedent, that is not inviting any response other than submission. The officer has to give the choice.
Fair enough, but I guess I'm just thinking about in the context of what was happening. Why was that not reasonably understood to be simply a condition of getting into the vehicle, into the trooper's vehicle?
I just don't believe that the record supports that conclusion. Again, it's a totality test, and the knowledge of the right to refuse is not a per se involuntary consent, but it is one factor that has to be considered. And other courts have recognized that when not only does the record indicate that the person didn't know they had a right to refuse, but when it appears that they believe they had no right to refuse because of an assertion of lawful authority, then that is not voluntary consent. That is just the particular facts of Mr. Berdahl's case. I think that this issue would be a lot easier if officers presented an actual choice, and I think we had that in Gao. That was really, appears to be a much clearer option, and it's really a matter of looking at the language used. That's why it's a totality test and not any per se rule. It's because the facts really matter.
So can I ask, would you be comfortable then with a rule that said officers are entitled to ask for consent to a pat-down before giving a courtesy ride, and that gives the potential passenger the option not to consent? But that in fact officers do have, that officer safety is a sufficient concern in this circumstance that they may require a pat-down if someone's going to get in the car?
Sure, the officers can always ask for consent, and that's true across the board. Even when they don't have a compelling government interest, that is sort of the premise of liberty, is that you have the choice. Even if it's a difficult choice, it has to be given. And when it's given, we have a framework for resolving whether that's a voluntary choice. And I think oftentimes it would be considered a voluntary choice when it's not merely an assertion of authority and followed by submission.
Now, what about, and I know that's not what we have here, but what about a situation where someone is unconscious or someone is so hysterical that they don't seem to be able to respond and the officer is concerned about safety, so can't get consent? In that situation, does an officer have a sufficient concern about safety to do a pat-down without consent?
Well, I think what you're describing are basically facts that could amount to reasonable suspicion under Terry. That, again, is an existing framework that if the officer can point to specific facts about the situation that are reasonable and reasonably give rise to a fear for safety, then that is simply a frisk situation that can require regardless of consent. And that is the beauty of rules that allow you to consider all of the facts, as opposed to a bright line rule, which is what GAO is and what the state is advocating. And that's really what we're concerned about here, is that this can just be resolved under existing Fourth Amendment framework, and that framework, the variety of exceptions we have, can accommodate the competing interests. If someone is hysterical, depending on the circumstances of that, certainly that could give rise to a reasonable fear.
Quite apart from fear, could I just pick up on Justice Hart's? Let's just move this completely to emergency doctrine. You started off talking about police caretaking functions. Would you agree then there could be such a situation and the police were responding to an emergency to take care of someone, not a law enforcement function?
Right.
And as part of that, could do something in the nature of a pat-down in order to protect themselves, or would that be outside the emergency doctrine?
Well, I think the situation you're describing is very similar to what you encountered in D'Andrea, which is the police have encountered somebody who is so intoxicated that they are, by definition, a danger to themselves and to others, and that is an emergency situation. And in deciding the balancing of interest in that case, this court still requires, and it is actually a statutory requirement also, that there be probable cause to believe that the person is a danger. And so you've got a proxy rule similar to reasonable suspicion or just general probable cause in the criminal context, but in the community caretaking context. And that's what the state's rule does not require, is there is no safeguard that the Supreme Court or other courts recognize in the context of non-criminal investigations is we either have to have particularized suspicion or we have to have uniformity of application. When you have neither of those things, then you have a real danger of a community caretaking search being used as a pretext for a criminal investigation. And that's why McCargo fell on the side of standardized policy. But on the other hand, I would disagree that a majority of courts have adopted this bright line rule. Several courts resolve it under existing frameworks where duty to transport and transportation is one factor that's to be considered. And I think it really matters what is the source of that duty. Is it because this person is dangerous? Then you have an increased officer safety risk. And again, it goes up the scale. And who is dangerous? You have to consider the privacy interest at stake. If it's somebody who is a suspected criminal, they have a reduced expectation. And that is the balancing test. And so, yes, I think the emergency situation is a factor. It's just not its own bright line exception. This court certainly didn't treat it that way in D'Andrea. I think it's just another factor. And indeed, that's Wisconsin's rule, is it's a reasonable suspicion standard where transportation is one of the circumstances that the court can consider.
Ms. Cruz, just ask you, if, despite all your good arguments today about why we shouldn't embrace something like the GAL rule, if we were to embrace GAL or some iteration of it, how would you suggest that we might refine the holding to get at some of the concerns that you're articulating in other ways?
Well, first of all, the seizure would have to be addressed. And it's not totally clear to me what standard the Attorney General is asserting. I guess we're talking about a Terry standard for the seizure, reasonable suspicion like standard where you have to have a reasonable and articulable basis to put someone in the car. I would definitely like a more defined standard than valid basis, which is what GAO says. That feels very amorphous to me. I'm concerned that that is merely resolving the seizure question, and traditionally in Fourth Amendment cases, you have to have a separate justification for the frisk, and that's really what we're here to discuss. So I don't disagree that the police officers need a valid basis for putting someone in a car, but again, under these circumstances and courtesy ride circumstances, that's really neither here nor there when it's a courtesy ride. So again, I'm concerned about the pat-down, and I think that this court would then need to require uniformity so that we don't have just people of a certain kind being patted down once they're placed in the car.
So would you be comfortable with our adopting something like the McCargo rule?
I think that that is a solution, of course, that courts have recognized. Taking a look at this court's recent decision in Brown, of course, you can't constitutionalize an unconstitutional search merely by making it routine. But again, what we're trying to do here is accommodate competing interests. And when we're outside of the context of criminal investigation, pretext matters. The Attorney General talked about Wren, and that you just need a merely objective basis. That's not true. Outside of the criminal context, pretext is fatal to a search. Wren itself says that the exception to the rule it is adopting is searches outside of criminal investigations. And because there is a concern that these so-called caretaking searches will be used as a pretext for investigation. And that's what a uniform policy helps to combat. Either you need particularized suspicion or you need uniformity because the Fourth Amendment is in play. It is not a one-factor test where you merely consider the compelling nature of the government interest, which is what the United States Supreme Court recognized in King. That's the case about taking DNA swabs. They said, look, this is a very compelling government interest, but that's not the end of the inquiry. We have to consider the privacy rights at stake. There, those were arrested, suspected criminals. Here, we're talking about ordinary citizens, and we need protections.
On that point, you seem to be describing something that sounds akin to an administrative search, say in the context of a courthouse or an airport, where ordinary citizens are routinely searched without suspicion, but uniformly so. In other words, everybody has to pass through the metal detector. Everybody has to have their bag scanned before you enter this secured space. And I'm wondering if you think of a patrol vehicle as sort of analogous to that, or if there's some difference.
Right. No, I think that that is an apt analogy in many ways, presuming, of course, as we do in the context of administrative searches at airports and courthouses, that people have the option of avoiding the search if they so choose. In the airport context, the courts...
They can walk away from the airport, or they can walk away from the courthouse. They can just choose not to enter. So they could choose to decline the courtesy ride.
Correct.
Okay.
And I think that's just the distinction on the facts of this case for Mr. Berdahl. But I don't think that that is a universal problem, that voluntary consent necessarily encompasses the right to refuse. And the airport cases, that's kind of an interesting case because, in fact, those were originally resolved on a Terry standard because they had a protocol for identifying who was more threatening. And they found that that approximated a reasonable suspicion, and it started out that way, morphed into administrative context when it became more uniform in application. But those cases really do focus on notice in advance, a right to deselect yourself because self-selection is a factor, particularly in the cases about screening at federal buildings. That was a big factor, is people who go to them are self-selecting. Not everyone has to pass through. And I think that that is really just, again, a question of voluntary consent.
Ms. Cruz, shifting gears a little bit, what do we do with the trial court's finding that the defendant's actions was just mere submission? I mean, it seems like that's consent. I mean, granted, it just feels like from the trial court's order, it was perfunctory, that due to the circumstances, there was no rational choice, and that's what he calls, he wouldn't entertain the legal fiction that he did.
Well, under United States precedent, mere submission is not voluntary consent. So that resolves that question. When you're only given the option to submit and you submit, we don't call that consent.
But I think what he's saying is that wasn't an order, it was just the circumstances where you're clearly getting in the car, you're going to freeze to death. So I got to pat you down.
And that part of its order was why the Court of Appeals remanded the first time, is because the court had focused too much on the subjective circumstances. But the aspect of the court's finding that when the officer tells you, I'm going to pat you down, and you submit, that is not called voluntary consent. And so that aspect of the ruling is correct and supported by the law. What the Court of Appeals found to be a problem was focusing too much on the subjective circumstances, which is similar to what this court encountered in Magdalena's Aragon, where the trial court found there was no voluntary consent because the defendant, a Mexican national, where there is no right to refuse, may have believed that even though he was told otherwise, he couldn't refuse. And this court said, no, that's not the question. The question is whether a reasonable person in the defendant's circumstances would have perceived the officer's conduct as coercive. And courts have recognized, including this court in Ektalib, very difficult to pronounce, that assertion of authority to search is a form of undue influence. That is coercion. But we also have, even under the totality of the circumstances, the prosecution has not met their burden of proving consent or voluntary consent.
Ms. Cruz, if I can jump in, you've kind of maybe answered this, but I'd like maybe a direct answer to the question. Justice Marcus asked Mr. Cooper, what about a rule that if a person willingly accepts or requests a courtesy ride, it's constitutionally permissible to do a limited pat-down? I'd be interested in your reaction to a rule like that. That seems quite limited. I'm not sure there's a pretext problem in that. But can you address that?
Right. So I'm sorry if this is not answering your question, but I just think that is a question of voluntary consent. And that if you're given the right to make a choice, and you make a choice, and under the totality of the circumstances, it's clear that was a voluntary choice, then you have voluntarily consented.
But I think it's presumed, and I'm just playing devil's advocate with you, I think the question sort of presumes it's my request. I'm the one asking you for the ride. So I'm voluntarily saying, what do I need to do to get a ride? I mean, I suppose maybe it's the, in exchange for the privilege of the ride, we're going to do this. Maybe it's a condition on that. I don't know. But it seems to me in that case, you presume voluntariness, I guess.
Well, I think you have to look at the totality of the circumstances, whether, the you have to be presented with a choice to make. Submit to the search and get a ride, or decline and not be searched. And that's what's absent under the facts of this case, but that doesn't mean that that's going to be absent in 99% of other cases, particularly if this court clarifies again that when it's a courtesy ride, simply give people a choice whether to refuse or not.
But doesn't that, and your time is limited, so I keep interrupting you, I apologize. I mean, isn't that presumed here? You know, Mr. Officer or Ms. Officer, can I get a ride? Well, sure, but I got to do a limited pat down here before you get in the car. Assume the position. Why doesn't that, I mean, the facts suggest consent there, as opposed to, you know, what I'm concerned is, you know, you're asking us to create a rule that there's an advisement the officers have to make in every case. That's troubling to me. I can understand the reason for some kind of clear rule on what an officer can do.
Well, when an officer wants to search someone, they need to ask, can I search you? That is the premise of consent.
But if I say, I'd like a ride, and it's really more Gow seems to be what happened. You know,
Right.
can you give me a ride? Okay, but I'm going to need to do a pat down.
Yes, and so
Done.
I think that's the distinction I would make here is that would be Gow. That is not Mr. Berdal's case. There's absolutely no evidence that he asked for the ride and was told.
But it's sort, and I apologize for interrupting because your time is short. But it's sort of like that. Would you like me to give you a ride to the gas station? And Mr. Berdal immediately assumes the position to allow the pat down. Why don't those facts suggest voluntary consent?
I disagree that those are the facts of this case. I think it's fairly apparent from the record that the officer did not believe that he could leave Mr. Berdal behind. It wasn't a choice in his mind either. And I believe that's why it was resolved the way it was resolved at the time, is because neither really felt that there was a choice. And the officer may have been mistaken about that if there is no legal duty, but it's pretty apparent that he felt that they couldn't leave Mr. Berdal behind, and so it was arranged, we're going to transport them, and when he approached the car, I'm going to pat you down. That is not a consensual situation.
As a policy matter, don't we want to encourage that? It seems to me the officer just did the human right moral thing here.
Absolutely, and I
your
don't
rule
see
would
any...
discourage that. I mean, the rule you're suggesting would say the officer says, okay, you're not going to let me do it. I'll leave you to freeze to death. What policy rationale is there for that?
We have, may I answer the question, Your Honor? We have a constitutional right to decide whether to accept help or not. And that's just the bottom line is we have a liberty right to make choices even if they're difficult. And that choice needs to be presented.
I appreciate it. Thank you.
I would just ask to affirm the Court of Appeals. Thank you.
As far as the framework for thinking about when risk is great and when it is lower, the correct way to understand that is that in the absence of a specific reason to believe that the person is armed and dangerous, the setting on the street is comparatively safe and the risk is therefore lower. In the confined space of the patrol car, the risk goes up. So that's the proper framework for understanding risk. I want to return to a question that was asked by Justice Boatwright earlier, which had to do with the parameters of a potential Gow rule. And the question was, well, should the pat-down only occur if the officer is going to be in the patrol car? There's another consideration, which is at the start of every shift and before anybody goes in, or after anybody is placed in and out, the officers search their own vehicle to make sure that there's no contraband in there. They do that for their own safety, and they do that for the safety of others who might later be put in there. And they do that so that if they later at the end of their shift find contraband there, they're going to be in a better position to say, well, I know that wasn't there at the outset. So the introduction of contraband concern, which might be a weapon or some other form of contraband, is another reason that even if it were true that the officer had no thought that the officer was ever going to be in the car, nonetheless, the search prior to putting the person in the car would be reasonable.
Mr. Cooper, you mentioned the Gao rule again. We keep saying this. I guess we can beat up on your colleague in a few minutes and find out what we think the Gao rule is. But what do you understand the Gao rule to be?
My understanding of the Gao rule is that if the police have a reasonable basis, which might be consent, it might be a detention, it might be some sort of emergent situation, if there's a constitutional reason for the person to be in the car, then the officers can conduct a pat-down.
Well, let me follow up just a minute. In Gao, we do have a question of a request for a ride, right? So are you suggesting, I don't understand you, but maybe, to be going so far as to say, once you make a request for a ride, there's no choice involved?
No, I'm not saying that. If the individual, upon seeing that there was going to be a pat-down and that that was a condition of the ride, wanted to choose not to ride, then of course the person, that is the way that the person could choose not to undergo.
And so I guess maybe the question, where you come up with two arguments, if I can say that, is what are you seeing as a valid basis to have somebody in a car apart from reasonable articulable suspicion or consent or an emergency?
Well, that may encompass it. It's examples such as Chavez-Barragan, where there's some basis, a reasonable basis for the officer to put the person in the car. It might be to get them out of traffic while they're being detained. Those are examples. Or emergency transport. All of those things are possibilities. There's no need for an explicit warning. Warnings are only required in something like the Miranda context, where there's a heightened custodial setting, something of that sort. And going back to Justice Marcus's earlier question about what should the, about the confined spaces in the courthouse, think about this. Reporting jurors don't have a choice about whether to go into the courthouse. They have to, and yet they're subjected to the search. So I think by analogy, that's a reason for thinking that even if the individual has no choice in going into the patrol car, the officer should be able to do the search. Thank you.
Thank you. We appreciate the arguments of both counsel. The court's going to be in recess for, what did we give ourselves, 15 minutes? And we'll come back and hear the second argument. Please be seated. Next case on our docket is styled Gao v. People. We've set this one for an hour. Both counsel look ready. Please begin your argument when you're ready.
May it please the court, my name is Julia Chamberlain, and I represent the appellant, Mr. Gao. Officer Sandoval saw Mr. Gao walking in a residential neighborhood. It is undisputed that Officer Sandoval did not receive any reports of criminal activity. He did not suspect that Mr. Gao was armed, dangerous, or intoxicated. He did not observe Mr. Gao commit any crimes or act otherwise erratically. He had no duty to transport Mr. Gao. And even in the prosecution's own words, Mr. Gao, quote, wasn't doing anything wrong. Based on these facts, the Court of Appeals created a new bright-line exception to the Fourth Amendment. It held that any time a person asks for a courtesy ride in a patrol car, the significantly heightened risk of danger to the officer justifies a pat-down search for weapons, irrespective of whether the officer has a reasonable, articulable suspicion that the person is armed and dangerous. When refusing to create a new exception to the warrant requirement, where another existing exception already applied to that situation, this court in Williams recognized that exceptions to the warrant requirement, however, must be carefully limited lest the Fourth Amendment's protections be eaten away by exceptions. Here, as in Williams, this court should decline to create a new bright-line exception to the Fourth Amendment because other well-established exceptions to the warrant requirement adequately protect the government's interests in officer safety during a courtesy ride in a patrol car situation. The Attorney General in Mr. Berdahl's case said, the officers have no tools in this type of situation. However, if an officer has probable cause to arrest a person, then he can conduct a search of that person before putting him in his patrol car. If an officer has reasonable and articulable suspicion that that person is armed and dangerous, then the officer can frisk him for a weapon before putting him in his patrol car. If an officer does not have reasonable suspicion or probable cause, then an officer can obtain their voluntary consent before searching them.
Let me jump in right there. So if we were to agree with you, would it be appropriate for us to remand for a hearing on whether there was voluntary consent?
Well, Your Honor, my first position would be that this court shouldn't address this issue because it's not properly before this court. The district attorney never sought a ruling on this issue. The attorney general never cross-petitioned on consent. And it's outside the scope of the cert question that this court is considering today. However, if this court does decide that it wants to address this issue, then Mr. Gao's position would be that a remand would be necessary so that the trial court can address this issue for the first time. Here there's disputed facts, critical disputed facts in the record surrounding the consent to search situation that haven't been resolved, and that prevents this court from addressing it for the first time on appeal. And one other tool that an officer also has in a courtesy ride in a patrol car situation, if an officer doesn't have probable cause, he doesn't have reasonable suspicion, the person does not consent to the search, then whereas here an officer's courtesy ride in a patrol car is entirely voluntary, the officer can decline to give the person a ride. So based on the facts in Mr. Gao's case, the Attorney General can't meet its heavy burden of showing that the exigencies of this situation warranted the creation of a new bright line exception.
Can I ask you a question? You said it's entirely voluntary, so the officer wouldn't have to give it, but isn't it also entirely voluntary and the person wouldn't have to take the ride?
Yes, Your Honor, this is a courtesy ride situation, so there's no duty to transport that's at issue in Mr. Gao's case.
And I guess picking up on where we were in the last argument, maybe you could address the question whether it's sufficiently implied that if somebody wants to ride and he knows he's going to be patted down in order to take that ride, is that a voluntary consent?
I don't think by just asking for a courtesy ride in a patrol car is enough to just imply that the person knew that that was going to be a condition. people that are not suspected of criminal activity, they don't forego their fundamental Fourth Amendment privacy rights simply for asking for help from an officer.
If they're told that they will have to be patted down, would you consider that a sufficient implication if they choose to go ahead and take the ride?
No, Your Honor, I don't think that's sufficient implication. I still think that you have to ask the question. Say, do you consent to a pat-down search? So in the last argument, one of the questions that was asked was about whether an officer has to give an advisement. It's not an advisement per se, it's just the question of, are you willing to consent to a search before I give you a pat-down ride? That would suffice in this situation.
So that much of an express question and answer you would require to find voluntary?
Yes, an express question and answer.
Well, this one's a little closer to being a question than maybe Berdahl, right? Because here it's something to the effect of, okay, but I've got to pat you down. Help me with the record here. Isn't that essentially what at least the police officer testified to?
Yes, Officer Sandoval testified that Mr. Gao asked for a ride to his friend Valerie's house, which was only 4 blocks away. And the officer, the direct quote, he said, "Sure, but I had to pat him down first before I had put him in the back of my vehicle to ensure that he didn't have any weapons or anything illegal on him." So that's what Officer Sandoval testified he said in response to Mr. Gao's question. However, again, I would just say that all of the circumstances surrounding the consent haven't been resolved by the district court.
Right. No, I understand that.
Yeah.
I'm just pointing out that it was more of an interrogatory here than it was maybe in Berdahl. And again, mindful that, in both situations, we have to look at the totality of the circumstances.
Certainly, and the district court didn't make critical findings of facts on disputed on disputed circumstances surrounding this consent. And in fact, Mr. Gao's testimony was drastically different regarding the consent. He testified that after the first encounter with Officer Sandoval, he was walking for 3 to 4 minutes, and Officer Sandoval was following him closely in his car, and it made him nervous. And Officer Sandoval stopped, got out of the car, and demanded to see the box. And so Mr. Gao testified he just gave the box in response to that demand. So these are critical facts that I think the district court will have to address in the first instance below.
Well, the credibility contest already was kind of resolved on those points, though, wasn't it? I'm not suggesting that we would want to resolve it without a remand if we went down the consent path. But now that you mention those facts, the court looked at that and decided that the officer was credible. And so I'm not sure that that particular credibility contest remains to be resolved. Am I wrong?
Well, Your Honor, I agree that the trial court did find that Officer Sandoval's testimony was credible. I would point out that there were some instances about his testimony that it was thought was suspect. For instance, the court was going through his testimony and said, there are things certainly that are not typical or not usual or often heard. For instance, somebody is alleged to have narcotics on them, flagging down an officer for a ride. So the court did question aspects of Officer Sandoval's testimony. But even setting that aside, even if you were to just, say Officer Sandoval's testimony is controlling on appeal, the court still didn't resolve other critical facts that it needed to address in the first instance. Voluntary consent is a totality of the circumstances test, which the district attorney has to prove by a preponderance of the evidence in the district court. And it's really the relationship between the officer's conduct and a person in the defendant's circumstances with his characteristics. So this test is part subjective and also part objective when looking at the totality of the circumstances. And here the trial court, even though it found Officer Sandoval credible, that didn't necessarily imply that Mr. Gao was not credible, especially when he testified about aspects of Officer Sandoval's encounter that he felt was overbearing or coercive. So the trial court still would need to resolve these facts down in the district court.
Can consent be gleaned from conduct? So for example, and I'll make it an extreme or more extreme case to make the point. So a person flags down an officer, may have a ride. Sure, but I'm going to need to do a pat down before you do. And then the person assumes the position to let the officer do it. Would you say there's consent implied in that case? So there's no advisement, right? No, you can say no. It just, can I have a ride? Sure. And then the person assumes a position.
Well, in that case, I think the question would be a little bit closer of a call because you don't have a defendant being, point blank asked, do you consent to the search, and have the defendant's response to that question. But it's a totality of the circumstances test. So in that situation which you're describing, courts would have to look at all of the factors together to determine whether the defendant's consent was voluntary.
And
or
I
not.
understand. So
Yeah.
those are the only facts.
Yeah.
Is that consent? Do we have consent? It's a hypothetical, if that's it.
Well, it's hard to tell. It's hard for me to answer that just because it's partly a subjective test too. So in the scenario you're describing, there's no indication about whether how the defendant felt, how he perceived the officer's actions, and there's also no here particularly there was also no factual determination on whether the officer Sandoval's conduct was overbearing or coercive, or could have been perceived that way by a defendant in Mr. Gallo's position.
Would it be fair for me to say then, going back to your answer to my question, that an express question and answer is not required?
Well, I think that there could be situations where there isn't an express question and not an express answer, and I think, like I said in response to Justice Gabriel's question, then it's a closer call, and you have to look at the totalities of the circumstances. But I think it's a much clearer record if that question is asked to the officer and then there's a response. But all these questions really do show that this creation of a new bright line exception to the Fourth Amendment was not necessary here. All of these questions keep going back to voluntary consent in Mr. Gallo's situation. And in fact, the Attorney General's primary position in her answer brief is that voluntary consent applies to this courtesy ride in a patrol car situation. And she argues that this court doesn't even need to address the question that it actually granted certiorari on. So Mr. Gallo's position is that, yes, voluntary consent does apply to courtesy ride in a patrol car situations. In fact, that's a tool that an officer can use in order to pat down someone before putting them in the patrol car. However, like I previously stated with Justice Hood, this question is not before the court today. And based on all the facts in Mr. Gallo's case, the Attorney General really can't meet its heavy burden of showing that it was imperative that this new bright line exception to the Fourth Amendment be created. So with that, if there's no further questions, I'd like to reserve the remainder of my time.
Let me ask you just one. I know you were in the courtroom for the last argument, and Justice Marcus asked a question that kind of suggested the possibility of a rule that would be fairly limited. If someone requests a courtesy ride or accepts one, a pat down is constitutionally permissible. I'd be interested, I know I asked Ms. Cruz that too, but I'd be interested in your reaction to such a rule.
So essentially, if I'm understanding the rule correctly, it's seemingly a voluntary consent rule. So if you ask for a courtesy ride, is that the understanding?
Yeah, and I think the difference is the rule sort of presumes consent in that situation. If I asked you for a ride and then you say, sure, but I got to pat you down, I've implicitly consented. I'm certainly not reading Justice Marcus's mind. I'm just asking you a question about such a rule. It seems to me that consent would be implicit in that situation.
Well, I don't think that a creation of a rule such as Justice Marcus stated in Mr. Berdahl's case would be necessary here, because this court in Williams stated that if another existing exception applies to that situation, there's no need to create unwarranted and unnecessary rules to the Fourth Amendment. So I don't think it's necessary here. I think both the Attorney General and I agree that voluntary consent would be an exception that could apply in a courtesy ride in a patrol car situation.
Thank you.
Good morning. Can I ask you a quick question before you sit?
Sure.
Sorry. So my understanding of the factual findings in this case is that Mr. Gao asked for a ride, and the officer then said something along the lines of, all right, well, I have to pat you down to check for weapons to make sure you don't have a weapon. And that Mr. Gao then said, okay. So I'm wondering why you think that's not sufficient for implied consent.
Sure. Well, first off, setting aside the fact that the trial court never addressed this issue in the first instance, I think that I do want to add on to that for a second, though, which is that really this court is doesn't find facts at this stage. The trial court needs to address this issue in the first instance. So if we're only looking at that question where Mr. Gao said, "Can I have a courtesy ride?" and Officer Sandoval responded, "Sure, I'm going to have to pat you down." That also doesn't address Mr. Gao's perceptions of Officer Sandoval and whether he thought his actions were overbearing or coercive. It doesn't look at any of the subjective aspects of the test. And I would also argue that when Officer Sandoval said, "Sure, I'm going to have to pat you down," that also could be seen as a submission to lawful authority because the officer wasn't giving Mr. Gao a choice on whether to consent or not. He erroneously stated that he had a lawful right to search Mr. Gao in that situation when Berdahl had actually, in a published decision, came out in October of 2012, 5 months before the officer submitted Mr. Gao to a pat-down search in a very similar situation here. Thank you.
Good morning. May it please the court. My name is Rebecca Adams. My registration number is 31044, and I represent the people of the state of Colorado. Now, my understanding of the Gao rule is this. As long as the circumstances reasonably justify the officer's decision to place an individual in a police car, the officer may require the person to submit to a pat-down search as a condition of their entry into the police car. Now, the Fourth Amendment only prescribes against unreasonable searches and seizures. So the critical inquiry here is whether or not this was reasonable. And the way that we determine that is by balancing the interests. We look at the public interest in officer safety versus the individual's right to privacy. And we look at the totality of the circumstances in the situation that we have before us. When we have a situation where the officer is inviting someone into the police car for a variety of reasons, it could be due to an emergency, it could be due to inclement weather, it could be a safety concern, the person could be intoxicated, or we could have what we have here, which was simply a courtesy ride. The officer is still going to be putting this person in the car. They'll be seated behind them in close proximity. The officer is going to have his hands on the wheel, his eyes on the road. He's not going to be able to observe the defendant. He's a single person watching with one other person behind him. And the individual in the back seat is separated merely by a grate, and he's not subject to the officer's immediate control. In this situation, the officer is extremely vulnerable to assault or injury.
Yeah, I guess
I saw it coming.
Right. Well, I get, nobody really seems to be contesting that there's a legitimate safety concern. I guess the question is how you go about getting at it. And I'm curious to hear your response to a question that the chief posed to Mr. Cooper about, well, you've got consent, you've got reasonable articulable suspicion under Terry, you have the emergency doctrine, exigent circumstances. Why don't existing exceptions encompass the array of situations that an officer might typically confront? Why do we need to carve out a new rule?
Well, I think certainly in many of these situations, and that's not the case here because this was clearly just a courtesy ride situation in this particular case, and I'm sure we'll talk more about consent as my argument goes on, but officers need guidance as far as how they should respond in these developing emergency type situations. And while consent was certainly an option in this particular case, it's not always going to be an option. I mean, we may have a situation due to age or mental health or physical injury or even intoxication where it's simply not reasonable to require the officers in those situations to obtain consent. So instead, what we're going to look at is there a reasonable basis to put these people in the car? And that's going to be how we make sure that this isn't used as a pretext or in some discriminatory fashion. We're going to make sure that there's a reasonable basis to put these people in the car before we require them to submit to a pat-down search.
I guess my concern is that's still an awfully broad rule, and I'm trying to drill down and think about the basis for it. In an emergency situation, the basis could be the emergency. In a detainee situation, it could be reasonable suspicion or probable cause. But in the courtesy ride situation, it strikes me that the rationale there is essentially one of consent. I've offered the ride, or I've accepted the ride, and I understand that this is now a condition of accepting that ride, and by proceeding to go forward with that, I've consented to the condition.
And I think that's certainly true in the facts that are presented in this case. I think this case could certainly be resolved based on consent alone. But I think there may be situations, and Berdahl may be one, where defense counsel in that case argued that the consent wouldn't be valid because the officer was basically holding this life-saving lifeline in front of him and saying, you must consent to this search or I'm not going to save you. And that the consent in that situation could never be valid. And we certainly don't, as a policy matter, want to require officers who are there to assist in the middle of the night in freezing cold temperatures to choose against their safety or the safety of the person who's stranded on the side of the road. As a policy matter, we want officers to be helping, and we want to make sure that they're safe in doing that. So in that particular situation, where defense counsel has already said that consent wouldn't be sufficient there, we need to make sure that officers have some guidance that they can go ahead and conduct a pat-down search in that situation to make sure that they're safe and to make sure that they can safely assist this other person.
But in Berdahl, if Mr. Berdahl had said no, then what, are you suggesting that the officer then could still conduct a pat-down search at that point? Let's say the same facts, and the officer said, I got to pat you down. And let's say Mr. Berdahl said, no, you're not patting me down. I'm not agreeing to that.
And again, I think in all of these cases, we have to look to whether or not it would be reasonable under the facts of that case for the officer to require that person to get into the car. And if we're really talking about a situation where the weather is such or the danger of the highway is such that he can't leave this person on the side of the road, it may be reasonable to require him against his objection to get into the car. And at that point, subject him to a pat-down search for the officer's own safety.
But we may then be dealing with an emergency or some other circumstance, right? We're talking about Gao and Berdahl. So in Berdahl, the facts that we have in Berdahl, if Mr. Berdahl had said no, your rule, the rule that you're proposing, would not envision the officer going against Mr. Berdahl's will and patting him down, right?
It would depend on whether or not it would be safe for the officer to leave him there. If he says, no, I don't want to ride, can he leave them on the side of the road in those particular circumstances? Is it safe for him to be walking on the road? Is it legal? Is the weather such that he really is going to be endangering his life if he stays there? And again, we don't want officers refusing to help people or deciding whether or not to protect their life or their own. They should be able to do both. Now, if it's a situation...
Can I just ask, are you saying then that if in the Berdahl situation, the officer determined that if he didn't put Berdahl in the car, Berdahl was going to die, then the officer could require Berdahl to get in the car and require him to submit to a pat-down?
Yes. If the totality of the circumstances determines that there's a reasonable basis to put the person in the car, then they can conduct a pat-down search.
And does that pretty much sound like you're saying the emergency doctrine is so broad that the officer could do what would otherwise be an invasion of the privacy of an individual, despite the fact that he's competent and says, no, I don't want you to save me from the emergency? The officer could nevertheless save him from the emergency and invade his privacy.
Correct.
Okay.
In the court, in many instances, has said due to special needs or emergency or community caretaking that certain searches are reasonable despite the lack of any individualized suspicion. And this is really just that same analysis here. Is this reasonable based on the totality of circumstances? And we weigh the risks to the officer and we weigh the privacy interests of the individual. And while certainly in this case, voluntary consent would be an appropriate way to resolve this case, there may be situations where it's simply not feasible to obtain consent. And we really need to provide officers with more guidance in these developing emergent situations so they know what they can and cannot do.
Can I ask you, sort of push it out a little bit? Not that this is an unheard of scenario that we've seen come up. Suppose the officer said, I'm the only one in the car. I'm not going to let you ride in the back seat unless I handcuff you. Would that be okay?
If it was a consent, a voluntary consent,
Well, we don't have any more than what we have in these situations. Or let's change it and say he thinks there's an emergency. The bird owl will freeze if he leaves him out there. And he says, but you're a big man, you're riding behind me, I'm going to have to cuff you. Can he do that and force him to take the ride?
I think that may be going too far. I think that the reason that the pat-down search is okay is because it's minimally intrusive. It's the minimum amount that can be done to assure the officer's safety. And so I think going beyond what's reasonably necessary to assure that the officer is safe would be going beyond what's appropriate. I think we would look to Terry and what is appropriate in those types of situations and apply that same rationale here in determining the scope.
You modified my hypothetical just a little and said going beyond what's necessary to keep himself safe.
My point being that the pat-down search is sufficient to determine whether this person is armed and dangerous. So going beyond that and handcuffing the individual in the back of the car, I think would exceed the permissible scope.
So if the officer was afraid that the guy might leap forward and choke him or cause him to drive off the road or anything, that would be unreasonable.
Well, and again, that would be different. In most police cars, we have a grate that separates the officer from the individual in the back seat. Possibly, if the circumstances were such that that was not the case, that might alter the analysis because we want to, but we want to make sure that this is the minimally intrusive. We want to use the least intrusive means to ensure the officer's safety. And so we would have to look at the totality of the circumstances.
Can I test your, were you done, Chief?
Yeah, please.
Can I test your theory about forcing him into the car? Let's take our situation here, and the police officer drives up to him and says, you better get in the car. You're walking with an apple box. You're in a bad part of town. It's 2:45 in the morning. Get in the car. Could he force him under those circumstances?
No.
What's the difference then between forcing Berdahl to get in and in Gao?
Well, and again, my understanding of Berdahl was that the individuals were hypothermic. They were miles from any gas station or buildings, things like that, and it was extremely cold late at night, and their health was indeed at risk by being on the side of the road at that time.
But aren't we really talking about shades of judgment?
I don't think so. In Mr. Gao's case, he was in a residential neighborhood 4 blocks from his destination.
Well, to my scenario, if he's in a tough part of town, could the police officer then force him?
I don't think under those circumstances that would be reasonable.
And how would we write a test a rule that would separate those two? What would our rule say?
Well, I think in many of these cases in the Fourth Amendment context, we're looking at the totality of the circumstances. And so we're asking trial courts to look objectively at all the circumstances that were presented and decide whether or not the officer's conduct was reasonable. So this is
So under that rule, are you putting the determination of whether an emergency exists in simply the subjective discretion of the officer?
No, I think we're looking at in an objective way. We're looking at all the circumstances that were available to the officer at the time, and we look at whether the facts that were available to the officer at the moment of this search and whether a man of reasonable caution would believe that the action that he took was appropriate. So again, this is an objective standard.
May I? So you talk about officers needing guidance. And I guess I find myself wondering whether a really ad hoc reasonableness inquiry provides them ultimately with less guidance than saying, look to these exceptions that have been carefully delineated over time through the case law, consider what you've been trained on with respect to consent, emergency, reasonable articulable suspicion. If we jettison all of that in favor of sort of a freewheeling reasonableness exercise, are we ultimately providing officers with less guidance potentially?
I don't think so. I think this rule says if you have a reasonable basis, a legitimate basis for placing someone in the police car, you may conduct a limited pat-down search for weapons to ensure your safety before you place the individual in the car.
Do you believe there was implied or express consent given by Mr. Gao here?
I do.
And do you believe there was express or implied consent in Berdahl or Berdahl?
As far as this particular case was concerned, in Mr. Gao's case, yes, there was absolutely consent. He flagged the officer down. He asked the officer to give him a ride to his friend's house 4 blocks away. The officer, who was at this point still seated in his patrol car, said, "Sure, but I have to pat you down for weapons to make sure you don't have any weapons." And the defendant at that point says, "Okay, I don't have any weapons." The officer then exits his patrol car. This is the very definition of consent that we have here.
Go ahead.
Well, let me give you a chance to finish, Justice Moore.
No, the only follow-up I was going to ask is then why do we need a new rule, if that answers it?
Well, it certainly answers it in this particular case. I think this case, as I argued in the Court of Appeals and argued again here, this case could have been decided on consent. There are other factual situations that may come up where consent wouldn't be appropriate, but that's certainly not the facts that we have here.
Can I vary your, oh, go ahead.
Could I just,
Yeah, no, go ahead.
all right, I just want to ask you to respond to Ms. Chamberlain's assertion that at the very least there would need to be a remand for additional fact-finding on consent for the reasons that she articulated.
I don't think that there needs to be a remand for factual findings. The trial court in this case found the officer's testimony credible on 2 separate occasions. It also went so far as to say the court is persuaded by the facts as relayed by the deputy. So the court not only found that the officer was credible, but also that it was persuaded by the facts as the officer testified to them. That's sufficient for this court to find that there was consent in this case. And with respect to the voluntariness of the consent, that's a question of law that this court can review de novo.
And if the chief will allow me, is the question properly before us?
Yes, this question is properly before this court. On appeal, a party can defend the trial court's judgment on any ground supported by the record, whether it was relied on or even considered by the trial court. And this court may affirm the trial court's denial of a motion to suppress on a ground different than those relied on by the trial court. In Arness, this court granted cert to determine whether the Court of Appeals erred in concluding that the police officer's entry into the home was unlawful under Payton. But it resolved the case on exigent circumstances, finding that because exigent circumstances was an exception to the Payton standard, the doctrine was so inextricably intertwined with Payton and with that analysis that the issue was properly before the court. And I think that's very similar to what we have here, where we have consent, which is an exception to the warrant requirement, and it's inextricably intertwined or fairly comprised of the issue that this court did grant cert on.
I hear that phrase and I immediately think res gestae now. You know, it's like Pavlovian, so just an aside.
But of course, the people would agree that if this court found the findings were insufficient, that a remand would be appropriate on that basis. Does the court have any further questions? If not, the people would ask that this court affirm the Court of Appeals.
Thank you.
I have just a few points that I'd like to make in rebuttal. The Court of Appeals already addressed whether it could decide the issue of consent for the first time. And there it actually stated that it couldn't because the trial court had never addressed this test in the first instance, and it's a totality of the circumstances test, and no findings were made in regards to it. So it stated already that its appellate record was insufficient to determine the issue of consent. I'd also like to bring this court's attention to its decision in Magallanes-Aragon. And there, the trial court found that the officer's actions were absolutely proper. And the prosecution argued that under the officer's testimony that it could decide consent because under the officer's version of the consent to search, it would not support a finding that it was involuntary. However, this court decided to address this issue for the first time on appeal because it found its appellate function was hindered. It stated that the court didn't make any findings regarding the circumstances surrounding consent. There was disputed testimony about it. The court never addressed the reasonable effect, if any, on the defendant and his perception of the officer's actions. The court never considered whether the police conduct was overbearing or coercive. And the court's finding that the officers acted properly did not necessarily imply that the officers found that the defendant's testimony on the consent to search was not credible. So all of these factual findings are not contained in this record. So like in Magellanus Aragon, Mr. Gao would ask that this court's appellate function is hindered to decide this first issue on appeal and would ask for remand if it chooses to address it. And then in regards to the Attorney General's position about reasonableness and looking at totality of the circumstances, just want to point out that under Terry, it found that a frisk for weapons is not a small intrusion, like the Attorney General kept saying. In fact, it's no petty indignity. It's a serious intrusion upon the sanctity of the person. And it shouldn't be taken lightly here, whereas in D'Andrea, this court found that in a non-criminal contact with an officer, a person's privacy interests are accorded maximum weight in this balancing in the reasonableness in test. And furthermore, just because an officer puts a person in the back of their patrol car, I agree that it does heighten the risk to officer safety slightly. However, this is a situation where the officer noticed nothing suspicious about Mr. Gao, nothing dangerous. And officer safety, while it is legitimate and weighty, and not in every single circumstances can it justify an intrusion into a person's liberty. So if there's no further questions, because the Attorney General argues that another exception applies to this case, Mr. Gao would ask that this court not create a new, unwarranted, and unnecessary exception to the Fourth Amendment. Thank you.
Thank you. Appreciate the arguments of both counsel. Case will stand submitted, and the court will be in recess until 1 o'clock.